I'm going to call Penny Henare.
Mr Chair, thank you very much. I rise to take this short call during the committee stage on the Employment Standards Legislation Bill, Mr Chair, and I'm reminded of a great piece of work done throughout the 1980s, which led to Pu Aotearoa Tū, and I've spoken about it plenty of times in this House. But Pu Aotearoa Tū refers to matua whāngai, and I think the great thing about some of the changes, the amendments that have been made to this particular bill, Mr Chair, really are in the vein of matua whāngai. However, I do, through the wise words of my colleague Jacinda Ardern, do want to put to this government, while perhaps if these kinds of changes can be made around the definition of a primary caregiver, whether or not adoption laws in this country can be reviewed, looked into, so that perhaps the term matua whāngai can apply there around a primary caregiver. But to the bill, Mr Chair, the meaning of primary carer, and it's in the communities that I represent in Tāmaki Makaurau, it's well known in the Māori and Pacific Island communities that it does take a village to raise a child. And in this particular amendment, Mr Chair, it's fantastic to see that we'll be able to stretch out what that means out of the realm of the traditional, in which Mr Nash has spoken about regarding mum and dad. The nature and the makeups of family today, we find in a heck of a lot of Māori families that I speak to, and indeed I belong to, Mr Chair, there are step-parents. There are other caregivers in that family, grandparents, aunties, uncles, who play a pivotal role in raising the children for the future. And if I can take this opportunity to quote the Right Honourable David Lange in his work, of which I'm sure Jacinda Ardern is familiar with, around the Before Five policy, which, you know, he talks about improvements in this sector are an investment in the future. And that's exactly what this particular piece is. So just to that one, Mr Chair, I want to congratulate, echo the sentiments of my colleagues and congratulate Sue Moroney on the fine piece of work that she's done in advocating for the needs of parents and families. Mr Chair, to clause 30H we have here, it's given provision to where the employee may refer the non-compliance with section 30D directly to mediation. Now, this is a new part in this particular bill, Mr Chair, that I think is a step in the right direction. I think it's a good thing because we know just how often and how much the labour inspectors and that particular sector actually struggle just to make sure that there are a lot of employers out there that do comply to the laws that we set here in Parliament. So while I applaud the step in the right direction to make it possible to go towards direct mediation or to a labour inspector, we will be keeping a keen eye on this particular government and the resources they give to ensure that they're able to enforce that they're able to give the capacity to those labour inspectors, to those people and to the arbitration courts and processes so that they can be carried to the letter of the law as it states here in 30H, Mr Chair. And I think that's it's a good move insofar as it's not just always about the employee. We're considering the employer here. And quite often, there doesn't need to be the intervention of a labour inspector, and maybe that particular employee feels that, and employer feel that they are in a position and in a healthy relationship, working relationship where they're able to actually deal with that themselves. So I think that's a positive move in the right direction, Mr Chair, but I do want to reiterate that we will be keeping a close eye on the capacity issues that we feel labour inspectors and the labour, I was about to say the Labour Department, but the Department of Labour and all of those that are involved in the mediation processes do actually receive the support and the resources from this particular government to make sure that they can do that. And to close up this particular part of my contribution and what will be a long evening, Mr Chair, I do want to say that while we applaud these particular changes in Part 1 to the bill, we have said this and we maintain this view that tinkering around the edges isn't going to solve the problem. So while we applaud the move to 18 weeks, we will be looking at making sure that's extended to 26 when we can. and we will be keeping an eye on this government. Kia ora.